County to answer is now in session. The Honorable Charles Hamlet presiding.
Thank you. You can be seated. Okay. Let's go on the record then file 22-5165-FH. If you all recall where we ended yesterday, the direct exam of Agent Impola by people was concluded, save for their request. They reserved relative to, my understanding is there's an individual that will have to deal with procedural matter today that relates to three proposed exhibits, but that part was reserved properly, so we can discuss that at the appropriate time. We left off with 260 through 264 being played. These were clips relating to an interview that Mr. Mahler gave. The first thing I wanted to cover, Mr. Cyber, yesterday he requested an instruction from the court. And so given that specific request, I just want to make sure that, I think orally I told the jury something similar. I don't remember my exact words, but I think I made clear what we requested. I just want to make sure that that's sufficient in your mind if you're requesting anything additional.
Thank you, Judge. We did appreciate that. I believe that you asked Agent Impola if the Nobles were involved in any of that. And then I believe you looked up at the jury and you said no. So thank you so much for your assistance.
And then Mr. Barnett indicated that he objected, obviously, at the time of the admission. We had that discussion. And then he thought perhaps he was going to possibly create some clips and or ask for the entirety of it to be played. Mr. Barnett, it's my understanding that you have three, I think it is, clips that are audio clips, not video, that would contain audio from the portions, what I'll call expanded portions as to three of the exhibits. Is that correct?
Yes, sir.
Okay. And I know there's a general objection, obviously, if you want to put on the record. So it's
Could I do say quite a bit right now?
okay.
But apparently on Sunday, an email went out with one clip. And I was directed to go to the OneDrive. I didn't see that video because I spent 13 hours with my client this weekend on 2 different days. I did see Mr. Cyber's response, which has been typical. It's not coming in, it's too late. So first of all, I didn't know these clips were even coming in. They did send them to me. I had to scroll down. It was sort of like missing a group text by the time I just saw Mr. Cyber's response, and I assumed it was one exhibit.
Can I just add, I don't mean to interrupt you, Mr. Wilson, this would be a link to the OneDrive that was sent.
Yes,
Okay, sorry.
and also a separate email sent to Mr. Barnett advising him that there's no
Okay,
comment.
I just want to make sure I understood.
I missed the email.
Okay, that's fine.
And the OneDrive, I wrote them back though, it said, hey, this is getting confusing. I'm gonna bring a thumb drive Monday. Can you put all of your exhibits on that thumb drive? So I brought the thumb drive, handed it to one of the attorneys. He went back and I figured he was pumping it all into the thumb drive. He came back and said, I got the videos for you. And we had just had a discussion before that the prosecutor's office had put Adam Fox's videos on for me. So I assumed they were at Adam Fox's videos. I had no idea Mr. Van Duzen's videos or these clips were on that video. So I found out yesterday, and the court gave us time to look at them, thank you. Gave us time to talk to my client. What I didn't have time to do was to pull up the 2-hour, 14, 12-minute, whatever interview that showed the context or lack thereof. And, the video is a truncated video to start with of my client's statement. I believe he gave 3 hours according to what Mr. Van Duzen's told me in the past. It's 2 hours and 12, 2 hours and 14 minutes, whatever. There's a lot of this interview not on this, and there's edits throughout. There's an edit, for example, what do you think of Dan now? I have to believe that Mr. Van Duzen asked him before that, what do you think of Dan in his case started? What do you think of him now? The only one they put in there is what do you think of Dan now, which my client, I think, called him paraphrasing, an F and C sucker. So that is and then it cuts off. And that's so prejudicial. Then they went to the Whitmer remark. And also, unnecessary, not probative, too prejudicial, emotionally charging the jury, changing the jury, prejudicing my client. Those two things, the seesucker comment and the robotic comment with the big word, totally unnecessary. So I have multiple objections here. First of all, it's late, it's well past August 7th. If I didn't say that yesterday, it might have been changed, but I wanted you to move past that. And it did come out after the 7th. And I've had access to it, but I listened to it once, not knowing. I need full context of anything that's coming in. I wasn't given that opportunity. So, first of all, I would ask that the entire tape be played, but there's a few seconds in there about the and both of the co-defendants. In fairness, this mess that's been created by putting these unfair clips in here should reflect on them anyway. I would ask that the tape come in, that portion be stricken. That's going to take some time to figure out exactly where that is. The tape's not the full tape anyway. It prejudiced my client so much with these two little clips alone, without getting into the heart of really what they did, which was way worse. So I am asking for a mistrial, if not a dismissal, based on the unfairness of these clips. And if the court's uncomfortable with that, I know the court hasn't heard the context, we've heard the tapes. It wasn't fair to the court to throw this on the court yesterday. It wasn't fair to the jury. It wasn't fair to me as Mr. Molitor's attorney. And I just got handed the actual notice of the clips. Got to listen to them, trying to process all this through. Went home, spent my night rather than preparing for cross-examination, trying to figure out how to undo this irreparable harm. Not only the seesucker comment, the robotic comment that came also to just snare my client. It's without any probative value. Totally outweighed by the prejudicial value, and they shouldn't have come in and created a partial travesty of justice. I want to get to the slow motion video, which is the only thing he really did in Antrim County, which was a duplicate video. But they clipped that in such an unfair way. I don't know if you say he was crazy or stupid, but they stopped it. They cut him off. They didn't let the statement continue, and whoever edited that should be in contempt of court for playing this, because it is misled. It's a misrepresentation of the facts. We already have this representation of the facts on Monday relative to the drive up, drive back. That raised a bell for a mistrial. We had another one yesterday. My client went to Walmart with the RF device. We didn't. He showed up at 1:37 in the afternoon or so at the FTX and handed the RF device at that time. That's on the 12th of September. What they said was this happened back on they said it happened on that date, which would imply my client knew about the 29th and everything that happened on that. And they showed up and explained it to Dan how it worked that day. No, he explained it to Dan, and we have the exhibit. It's one of our exhibits, a 20-minute clip that says on August 29th, before they went on the ride, before my client knew anything about Adam's crazy ideas, he said, hey, look at my RF device. That happened again on the 29th of August, not on the 12th of September. They misrepresented yet another fact, either inadvertence or incompetence. They've had this case for 4 years. They don't know their evidence. It's sworn testimony looking at the jury. It's not fair. That's the second bell, and I'm going to show the bell at some point if we get to this. But Dan, my client never went to Walmart in the morning. He drove alone. He was driven by a garden on a four-wheeler, side by side, from the camp to his car. Everybody that went to Walmart to get a ride and go in a group to the event, the FTX. So they've provided false testimony in two ways. Those bells can't be unrung. I haven't proven it yet. I have an exhibit today where they actually did hand off or show the device and explain it. My client was not at Walmart. And now they put in false testimony that puts him there on the 12th, bringing an RF device. knowing what he knew back from the 29th of August, he brought it at 1:37, he handed it to Adam, and Adam did his thing. So I'm telling you, we're up to bell number 3 now. It's the slow motion video clip that I do want to play. But they've cut it off in such a prejudicial way, the jury went home to think about this, and throw in the cocksucker comments and the effing whatever of the governor. And then there's also the Boogaloo boys comment, the bad guys, good guys comment, which is, you know, how do you tell somebody, they cut these things short. But the video's been edited. I would like to call Mr. Van Dusen to testify that the video's been edited. And that it is an hour and a half that we don't have. I don't know what's on there. I'd like to have that before we proceed. We can't stop this trial right now with that going on. What they played yesterday, they knew was edited. You could see in the video, goes black for a second and have something slide over. He's got an edited tape and they're bringing in not complete evidence. I'm getting to 106, Your Honor, which reads, when the writing of recorded statement or part thereof is introduced by a party, and after this party may require the introduction at that time. That's where we are today. At that time, we're here. And I just want to put emphasis on that. Any other part or any other writing or recorded statement which ought, in fairness, to be considered contemporaneously with. And there's some cases to go with that, but that's the court rule. In this case, by allowing a journalist interview to come in, that was not complete. It was edited. It doesn't show what the question was. What do you think of Dan now? The video, it clips the video. Mr. Cyber used a bad word earlier, said tampered. It's not tampered, but this is conveniently clipped to shortcut his answer on the slow motion video.
Which exhibits, so 260 through 264 were admitted. Which 3 clips that were admitted as exhibits do you propose to play a longer?
I think, no, it's 264. That's the main one, the slow motion video. I just had these numbers added on momentarily, so I won't know. I will call them. Maybe my brother counsel can help me here. But there's a slow motion video clip that was truncated. The Little Boys clip, which is truncated. And I'll call it good boys, good guys, bad guys comment. Video was truncated. We can play them and we can identify them after the play. They're being stipulated to. I'm not going to play the governor's comment that they made. The court heard that, how prejudicial it was, and I can start and the court heard the sea-sucker word, abbreviating that.
Yeah, I think that was 260 and 261. So is it 262, 263, and 264?
I need some help with that.
That's not correct, Mr. Wilson.
I'm sorry, Judge.
So I think the 2 that he was referencing as to CHS and governor, I recall correctly, that's 260 and 261. So the list that he has in reference to 262, 263, and 264.
Yes.
And the reason I'm asking is because what I'd like to do this morning before we bring the jury back, and I'll say, I don't know that I said that, but clearly the jury's not important just for purposes of the record, is play the clip that was admitted yesterday, followed by the proposed exhibit by Mr. Barnett. So that's why I want to know which one.
And the court is correct as to its recitation. The slow motion video was 264. I believe that's Mr. Barnett's proposed exhibit I, like India. What are your thoughts about the Boogaloo Boys was our exhibit 262. That is Mr. Barnett's proposed exhibit K Kilo and K. And then the third one was how do you differentiate between talk and action? That was our exhibit 263. And that's Mr. Barnett's proposed exhibit L Lima.
We went from I, K to L, and upgraded my alphabet.
You removed one, which was, what do you think of Dan? And that was your proposed exhibit J, Joliet.
But I also removed the governor's comments too, which
So we're talking, okay, yep, so we're talking 263 relates to proposed exhibit K, as in kilo, 263 relates to proposed exhibit L, as in Lima, and 264 relates to proposed exhibit I, as in India. Is that correct?
yes.
Okay.
And I guess we could put J number not being brought in. J would be a Dan comment, but again, ask the court. And I think the court should look at the entire 2-hour video, first of all, and make, in court here, figure out whether that should have come in either, because it looks like there was a question asked. There's a black card right before it where they obviously edited. What did you think of Dan when the arrest happened? What did you think of Dan now? There's only one reason he would say now, I'm guessing. I'd like to know that from Mr. Benjamin. Want break, but you have to. I don't know how they get a 3-hour video from somebody who's in the press. They've chosen to use the press interview. How do I get to the rule of completeness now? And none of us have seen a 3-hour video. I think we've all watched the 2-hour video. I'm objecting to what's happened. I don't want to say that it was such a false representations, like they have tainted the jury. There's no context. They had no time to really review the context yesterday. They were prejudiced by that. They did emotionally harm the jury. They cut off portions that provide context, explanation.
Okay,
This is
that's the same discussion that we've had. So let's do this, because as the court indicated, I didn't listen to the 5 clips that I referenced as 260 to 264. When I talked to the attorneys about them in chambers, they were so short in time that I just had the attorneys tell me what were on the tapes so that I was aware of the content so that I could make that decision. But given that these proposed clips by Mr. Barnett will be longer in time, what I'd like to do, Mr. Ralston, if you can all call up, let's start with 262.
Yes, sir.
And then what I'd like to do is play your clip, followed by the proposed clip from Mr. Barnett, so that I can better understand what we're talking about. And then we'll move on 263 and then to Lima, 264 and then to India. Okay?
Thank you.
Okay. Yeah, we're going to go numerically with people's exhibit numbers, so 260.
What are your thoughts on the Blue Boys? Okay, and what is the version of Blue that we're representing, first of all? Because it's not what the government saying. It's not anarchist stating it, right? My understanding of it, and again, I guess that's become not a personal opinion or what I've heard about it, is the movement would be a fight against our government. Right? That would be like another civil war, I guess.
Okay, and so that was people exhibit 262. Right here, proposed exhibit K as in kilo.
Just a second.
Sure.
I believe it's this one. I have this at 3 minutes and 32 seconds. I don't know how there's false, but it's much shorter. I'm hoping I'm getting the right talking to you.
All right. And what are your thoughts on the Blue Boys? Okay, what is the version of Boogaloo that we're representing here, first of all? Because it's not what the government's saying. It's not an anarchist sticking up, right? My understanding of it, and again, I guess this can come down to personal opinion or what I've heard about it, is the Boogaloo would be a fight against our government, right? That would be the Boogaloo. It would be like another civil war, I guess. It's not something that should be looked forward to, and I think that anybody who says otherwise, here's something that irritates me. Any motherfucker that stands up and says, "Oh, I'm ready to shoot somebody," That's the easiest thing for you. You're waiting to fucking kill another American. There's something wrong with you, motherfucker. You know, that shit bothers me. The boogaloo should be the last resort because you've already tried doing stuff. These motherfuckers want to pull the trigger on another human being. People say this shit, they don't realize what real violence is, what it actually does to you, what it looks like. You know, it's real easy to do this shit. I think that should be the last resort.
On the Boogaloo Boy issue,
Yes.
You brought up the Civil War, and you know, from my experience in doing research on the Boogaloo, it runs the gamut from what I guess you would call accelerationist. Have you heard that term before?
No, but I understand.
Okay, so an accelerationist, from my limited research on it, is someone that is not only believe that a civil war is inevitable, which I think most of the mainstream Boogaloo Boy movement believe that a civil war is imminent. The accelerationists want to bring it about.
Yeah.
And so what's your take on the potential of a civil war breaking out in the United States?
Scares the shit out of me. It scares the shit out of me. I like being able to sit in my house and not have to worry about roving bands of cocksuckers, wanting to come rape, pillage, and kill people, because that will happen. You will find factions of people. You would be surprised how fast things fall apart, and people are, I'm so sorry. I rabbit hole on this stuff because there's so much that goes into it. Your questions are simple, but there's so much that goes into the question, for an answer.
So I guess, do you believe that a civil war is inevitable here in the United States because of what you've seen?
I'm going to say that civil war is inevitable, and no matter what country, no matter what government you have in place, because you're always going to have people who don't agree with the other side. And it eventually will culminate to something. I mean, just look at history. It's constant. There is not one country that's ever existed without civil war every once in a while. It is going to happen. It's cyclic. So yes, I think it's inevitable. I don't know if it's going to happen in my time. I'm hoping that people can invest themselves into learning and using the system the way it's supposed to be used to avoid it as long as possible. The last thing anybody should want to do is fight another human being.
What are your thoughts about using violence to resolve political differences or disputes?
Well,
So, then it's a full clip, there is a question at the end, I would try to pause that. If we were to play this, I'm still playing the entire tape, there's some comments to it.
So this is less the question at the end, to which no answer is provided, that would be your proposal, okay?
I would do my best to shut that down as soon as I hear the recordings.
Okay, I just want to make sure I'm understanding what.
Yeah.
Okay.
They prosecution was asked to have that trim, I can't trim it without manually jumping on my phone here.
Sure. Okay, and if we could have 263 played, please.
Could that be described as at the Boogaloo Boys?
No, I guess I can go back to my.
No crime unless someone gets hurt.
Okay.
Sorry, that's what I meant.
Okay. And this would go with proposed Lima, is that correct?
Proposed what?
Yes.
Lima, L.
Yep.
Yes, okay.
Let's start with 263, please.
How would you believe someone should differentiate between violent rhetoric compared to, just blowing off steam? How do you know whether or not someone's serious?
I'm very black and white. There's no crime until something happens. And I'm sorry that something has to happen, that somebody has to get hurt in order for my opinion to matter here. But if nothing has happened, there is no victim. Once there is a victim, then the individual who did the crime needs to be dealt with.
And then if we could play Lima, please, L.
How do you differentiate, like we talked about the gun issue, how to differentiate between who's a bad guy, who's a good guy? How would you believe someone should differentiate between like violent rhetoric compared to, just blowing off steam? How do you know whether or not someone's serious?
I'm very black and white. There is no crime until something happens. And I'm sorry that something has to happen, that somebody has to get hurt in order for my opinion to matter here. But if nothing has happened, there is no victim. Once there is a victim, then the individual who did the crime needs to be dealt with. Innocent people who had nothing to do with it should not have any regulations placed on them because of something that somebody else did. That is not fair.
So you and I met for the first time in August of last year, 2020, or 2022.
Okay, so that was proposed Lima. Is that the same as before with the end portion where Mr. Van Dusen is asking, I think the beginning of a question would be removed?
I will do my best to shut that down.
I'm just asking.
That's what I go. The Boogaloo Boys was what you're under, this is Lima, I just want to. It's K, thank you. So,
Okay, and then if we could have 264, please.
okay, this is the one that you're under, this is the one that is reason to mistrial this or dismiss it.
And this is the clip that my notes are correct regarding the slow mode tape. Is that
Yeah.
right? Okay.
The only thing they have against my client in this county, it has been edited.
Okay, we'll talk on this one. Number 264, please.
So when you were driving down, I think it's Timberlake Drive on Birchley, and Adam handed you his phone, and you took a slow-mo video that contained Governor Whitmer's vacation home in that slow-mo video. What did you think you were doing when you did that?
Oh, I know exactly what that was. I mean, it's obvious. He said, we take a slow, a video while we drive by. I'm not stupid.
Okay. And then I believe this one is proposed exhibit I for India. Thank you.
So when you were driving down, I think it's Timberlake Drive on Birchley, and Adam handed you his phone, and you took a slow-mo video that contained Governor Whitmer's vacation home in that slow-mo video. What did you think you were doing when you did that?
Oh, I know exactly what that was. I mean, it's obvious. He said, we take a slow, or a video while we drive by. I'm not stupid. How do you say no to somebody not knowing how far they want to go to keep you quiet? I don't know him. I do not know Dan at all. I shook Adam's hand once and I saw him on a fucking chat. You know?
So you
If I gotta take a video and get home to my kids, I'll do it again.
would you? It sounds like you're asserting that you potentially were under duress when you did that.
It would be, except for they did not coerce me to do it. They did not actually tell me if you don't do it, you will be injured. I did not want to give them the opportunity to think that I would not be okay with them because they now know where the fuck I live. My mom is here who's not in the best of health. My kids are here. I had custody of my kids, dude.
So that was on April 29th of 2020, correct?
Okay.
When that daytime, I guess, surveillance occurred. That was April 29th.
I don't have a date in my head or directly.
From my recall, I think it was April 29th.
Okay.
And then you were also, subsequent to that, you went to a training in Luther
Yes.
on September 12th and 13th.
There was an error by the journalist that he didn't get April 29th, it should have been August 29th. I can try to shut that off right there. Complete statement. This is what should have been put to the jury. To cut off, I'm not stupid or crazy, whatever he said, I think it was stupid, wasn't it? Yeah. And then went into full explanation of why he took the video.
Okay, hang on, we're not gonna talk about individuals. So, similarly with the other two, Mr. Van Dusen was speaking at the end, would that portion be clipped off?
Yeah.
Okay.
Just as soon as I figured it
Judge,
out.
what he's saying, I think, is I'm gonna try to turn it off the best I
No,
can.
I know, we're gonna work through that. That's
Okay,
not what we're
that's-
gonna do. That's what I'm asking. And those would be the three clips related to the three exhibits that you would seek to admit pursuant to MRE 106.
Yeah, well, won't play the entire tape, yes, Your Honor.
Okay, and you are asking for the entirety to be played.
I am, and I'm asking to have the journalist take the stand to explain that this is a 3.5 hour video shot down to this. would also like the video shown to the court and how it was edited clearly, and that the prosecution knew this thing was edited before they went to this bucket. And it's a misrepresentation, Your Honor, very desperate. I cannot believe that this has happened in this case. It's unfair.
We'll go through all of that in just a moment. If the other attorneys had an opportunity to listen to the 3 clips, that being Kilo, Lima, and India, is that correct?
That's correct, Your Honor.
Mr. Nunzio, any issue with those being admitted from your perspective?
We do not, but we need to register an objection that if anything comes in total that is against the those, Mike and Bill, then we would have to register a formal objection regarding the countervailing theories of defense being pinned against each other sitting at the same table. So, but I know the court's aware of that. It's my understanding that that's not coming in, but we registered a formal objection. Because then it besets other issues that we have to address if any of the tape or recordings come in that are contrary to.
And that would be if the entirety was played without removing the reference.
That's correct. Right? So we just want to register that objection right now. Thank you.
Thank you, Mr. Patterson.
Judge, we concur with Mr. Nunzio. We'd also ask that the court instruct the jury that the nulls were not a part of this interview, had nothing to do with it, and they didn't even know about it. Thank you.
Okay, Mr. Wilson, let me start with you in terms of the admission of these 3 proposed exhibits.
Sure.
Lima and India.
Yep.
And then move through each part of the discussion in this session.
Okay. We don't object. That's fine. Might be a good idea to inquire of Mr. Molitor if this is what he wants, because obviously some people may view that evidence as damaging and repeating itself to the jury.
Well, I certainly have respect Mr. Barnett with his line, they can make that determination. Do the people have a position on the request to play the full portion? And when I say full portion, I mean the 2-hour, whatever was publicly available.
Yeah, I don't think a showing under 106 has been made that that's required. I mean, he's replying to, 106 obviously pertains to what we put in. He suggests it's out of context. We have no problem with those 3 coming in because they directly relate to the 3 exhibits that that are in question here.
Okay. And then do you have a position on the request to declare mistrial?
Yeah, there's, Mr. Barnett keeps talking about, prejudicial nature of the evidence. Justice Weaver in 1995 was the author of People versus Vasher, Vasher, and that's found at 449 Mish 494. And in part, Justice Weaver writes, prejudice means more than simply damage to the opponent's cause. I mean, a party's case is always damaged by evidence that the facts are contrary to his contentions. But that cannot be grounds for exclusion. I mean, and that's the nature of trial work. That's the nature of presentation of evidence. It's, yes, when evidence comes in, it's probably going to be damaging to one party's case. There's an assertion that Mr. Barnett makes in several different ways about his disagreement with the evidence. And that's perfectly fit for cross-examination. And if he wants to present evidence to the contrary that we've presented, then so be it. I mean, to suggest that that's the basis for a mistrial, that is not the foundation for which mistrials are for. I mean, mistrials are for, manifest, such an error has occurred that it's a manifest necessity. Part of it is he weaves in really a discovery issue. And I want to just take 45 seconds here to make sure that our position is clearly mapped out on the record should this be an issue on appeal. On Sunday, August 20th, Mr. Van Dusen published the article that we harvested the clips out of that were put on yesterday. open to the public domain. We made the court aware of this on the first day of trial, along with counsel, Mr. Barnett, and that we would probably be taking some clips from that and using them in our case in chief. Asked for the court's leave because obviously the August 7th date, which was the due date for exhibits, had passed, but they weren't in our possession prior to that date. And then we come to August 27th. That is last Sunday. Mr. Barnett was, we uploaded the clips that we intended to use to the OneDrive. That's been our main mechanism for delivery of discovery to all counsel. And we also sent a separate email to Mr. Barnett indicating that there was a new upload. And then Tuesday of this week, the 29th, Mr. Barnett provided us with a thumb drive, and it was very clear what we were turning over in that thumb drive. That it was the clips that we had referenced to the court on the first day of trial. So Mr. Barnett is not a victim here. He has not been treated shabbily or unfairly. And I resist his temptation to try to accuse us of improper conduct. And the discovery was provided in a timely way. And really what it gets down to here is he disagrees with the evidence. So be it. Cross-examine the witness. We're ready to continue on, Judge. Any questions? Thank you.
Mr. Barnett,
Yes, it's not improper conduct. There was a miscommunication between me and them. I'm working on things. They're sending me emails that I'm not able to keep up with.
excellent.
And it's not improper conduct in that regard. The improper conduct is clipping a tape like that and leaving the jury with also the other in the context. They want the context of this whole interview shows my client's ideology, shows his intent. The whole thing does. To just take little clips out of that picture, that landscape that I tried talking about. I tried having this not come in yesterday, but I didn't know all the reasons until I heard the rest of the tape. Sorry, I had heard the rest of these clips. Two of them were highly prejudicial. One looks like I don't have the rest of the tape. I'd like to have Mr. Van Dusen at least tell the court under oath that there's more tape here. That if I want to bring in a complete statement under 106, I haven't seen it. I've heard the whole tape. So, and then they've edited it. I've asked him if he edited this thing. Edited it. I would ask him, was there a question about Dan at first? And now how do you feel about it? Usually when someone says, well, now how do you feel about him? They've already asked them, how do you feel about him when this case started? There's a huge difference with my client. But this is, you add in the other problems we've had in the case, 2 bells, the Walmart discrepancy that's going to come out, which we can take care of at this time if you want to. And that they just talked to Dan, I think they just found out that my client did not go to Walmart that day. That my client did not say that statement 1 minute after he got in the truck, after Adam said he wanted to blow up the ball. Again, on a mission. Make it look like he's known about it forever. And now they have him on Walmart at 10:30 in the morning. This is number 3. This is so prejudicial. And the worst one is the slow motion video clip that they cut off and said, you know, what do you think, I'm stupid? They went home thinking about that in conjunction with these other nasty clips. His language is bad. I warned the jury when this case started. But this is a Harvard trick. What they did was the slow motion video. It is editing to create a false representation, a false light to the court. It's sanctionable, and in other words, the highest sanction should be given in this, which is dismissal. The court has that ability to do that. The jury's been sworn in. We've wasted all this time to have this happen, and you create an unfair playing field for my client. It's irreparable, the harm that's happened. The entire thing's edited. I'd like to call Mr. Van Dusen at this time and have him describe what's out of the tape and the kind of injustice. He's watched the whole thing. Maybe he can provide some opinion as a person that's done the tape and as a professional in this field. But in fact, I saw a comment today the newspaper that he felt this was an injustice as an offer of proof to the court. He said, hoping that the record he reported was accurate to the court. She usually is. But I would like to put him on the stand at this point, at least to test the water, to let the court know, even as an officer of the court, he's told me before about the length of the tape and how much was cut out. So complete picture under 106 would be the entire video, which includes his kids, includes who knows what, I don't know what else. There's some other things in there that shouldn't have come in. I guess we take care of one portion, which would be kids are in the video. Now we've got kids in the video, and that's the complete statement. I guess we can take them out as well. But I haven't seen the whole video to know whether I can argue 106 or not. I've seen the pictures. So with that said, I would ask the court to provide the ultimate sanction in this case, that the court dismiss this, that the misconduct, the improper conduct be attributed to. I know it's not Mr. Rolston, although he is in charge. He's the gatekeeper. This is the FBI doing this. Someone has edited this video, especially the slow motion video, in such a prejudicial manner that there's no way that we can unring that valve and change or repair the harm. And I don't know if there's harm to the nulls. There's been good structure, there will be. But as far as Mr. Molitor, this is a case that should be dismissed right now. If not in this trial, I would ask the court to consider appointing counsel on this issue. That is how serious I feel about this. The interlocutory appeal, I don't do appeals. That would be the court appointed attorney to do that. I would also ask the court to either individually in our presence interview the jury or as a whole and see if they're going to be fair and impartial after hearing these clips that they heard yesterday. And just playing these longer, fair versions to a degree, although they're still taken out of context of the entire video, for which we don't have.
Okay, I understand relative to the language of the courts. Is there any additional argument you have for communication tool?
I think I've covered everything, and I appreciate the court's patience and the way the court's looking at this.
Mr. Nunzio, I don't recall if I asked you relative to the mistrial request.
No, Your Honor, related to the court's discretion, if I can bring this to the court's attention. As the court knows, we've had a number of breaks that have been lengthy over the past several days. And I understand that's part of the trial. My concern, my request at this time is that the court remind the jury that deliberations are not to begin until the end of the case. I just think with jurors sitting in rooms for an hour, a couple hours at a time, the temptation's there. And if the court would remind the jury, certainly without objection, that they should not be deliberating and or discussing this case, comparing notes. We greatly appreciate that, Your Honor. Thank you.
I would note to Mr. Cyber, I'll get to you just 1 second, I didn't forget you. We did get a note from the jurors that sort of dealt with timeliness issue. And so I think in answer to that, the court will include a reminder relative to that. I think that provides a good opportunity.
Thank you very much, Your Honor.
Mr. Cyber, anything additional for you or your position on the request for this?
Judge, please stand with counsel. I know the jury's been back there for a long time. If we are going to be more than another hour and a half on this, we might want to consider releasing the jury to watch.
We're not going to be another hour. Mr. Wilson, anything else for you?
Just one point, Judge. Mr. Barnett wants to put in the version of the interview that Mr. Van Dusen produced publicly. First of all, to suggest that the 2 hours and 14 minutes is providing the context to the clips that we put in under 106, I think is a misstatement. It's, he hasn't offered the court how that entire 2 hours and 14 minutes would be relevant to add context under 106 to the statements that we entered yesterday. So absent that, the rest of it becomes hearsay, not a court statement. And it would be prohibited under the hearsay rule. It's, if I wanted to put it in, I guess we could under, admission by party opponent, but he can't put his own client's statements in And to be quite frank, I mean, the reason he wants to get him in is because it's very sympathetic. He's got his kids running around, his mom, his dog, you know, he has failed to demonstrate how the entire 2 hours and 14 minutes would be relevant to add context to the statements that we put in yesterday.
Well, there's a lot of things to cover there. Let's start with evidence generally, and the court has reviewed this a couple of times in terms of the court, if they were certainly parties put forth proposed exhibits, they have to comport with rules from the court, rules of evidence, those types of things. We've had extensive discussion in motion practice relative to a lot of the objections. The court asked the parties to file written objections, which is why Mr. Cybers says stand on the written objections. And so those have been dealt with, findings have been made by the court. And certainly aside from what Mr. Ralston quoted, I think the quote, and I may have said it at one point, because it's one that folks use all the time, is that evidence is always prejudicial. I mean, I forget the exact, that's paraphrasing whatever that line is from the case. That's the very nature by which it's offered, right? Otherwise, a party wouldn't be able to claim it's relevant. And so the question is not, is it prejudicial or is it damaging, right? Depending on which phrase you want to use. The question is the probative value, we start there, and does the prejudicial effect or nature of that so far exceed the probative value that it becomes improper? And the ruling that the court made yesterday, after being told the contents of the 5 clips, I certainly take to heart the objections that were made. I don't ever mean to make light of any of those. I'm afraid because bad words were said, cuss words, swear words, whatever phrasing we want to use. I think that everybody's familiar with those in today's society, even if we don't say them. Plus, there have been many that have come in other exhibits, perhaps not attributable to any one defendant necessarily, but there certainly have been plenty of words. I mean, the name of one chapter that was put up included those. So I don't think in the court's mind there's nothing so prejudicial about that, even when those words are applied to a particular person, that exceeds the probative value that the court determined exists. And so as to those clips in particular, the court doesn't have any issue, as was defined yesterday. That was 260 and 261, I believe. In terms of 262, 263, 264, the exhibits that have been proposed, Kilo, Lima, and India, at least if the court is not going to allow the full portion of it, the other parties don't object to those 3 clips coming in. And the question for a court with 106, I'm not going to reread it because Mr. Barnett read it, is the idea of how to provide context to a particular comment. And the showing has to be made that it relates back to the original exhibit. And, parties, if there's a video, parties put forth, as I indicated, proposed exhibits. That may be a 10-second clip, 30-second clip, whatever they believe is relevant and assists and helps with their case. And so long as it comports with the case law, court rules of evidence, whatever we want to analyze it under, it can be admitted. The court did determine that 260 through 264 were appropriate under the current standards. So that's why the court did admit those. Certainly, in what we request under 106, which is appropriate for the attorney to ask for in each given scenario, and we've had other discussions outside of this 106. The question is providing context and a longer answer, so to speak. If it's a question or interview that explains what that party feels is an unfair characterization. After listening to Kilo, Lima, and India, the court does believe that those clips provide a sufficient timeline, as requested by Mr. Barnett, to be able to explain in more detail how he has indicated that Mr. Molitor was misquoted or the implications that come with the shorter clips, the longer clips that he has prepared under those letters. To do that in the court's mind and are sufficient under 106, a full playing of the, I'm going to say 2 hours and 14 minutes. I don't know the minutes fully, whether it's 212, 213, or 14. But the full interview that is posted online that's been referenced by the parties, the court at this point doesn't feel that it needs to listen to that full portion, given my finding that I think that those 3 letter clips meet the standard under 106 and you meet the request Mr. Barnett. The court is also not going to bring Mr. Van Dusen forward. I don't have the authority to do that, nor would I, given the circumstances of why he's here or how he produced that information. It was publicly provided. I don't recall if it was posted publicly and sent to the parties or just posted online. But certainly it was provided to everybody under that capacity. And so the court is going to bring him forward to explain that. And to say that the interview was edited and to automatically imply that that's a negative, the court would presume and assume that most interviews that are conducted in that fashion, a sit-down interview with a journalist, are edited for time, meaning that if an interview is put forward at, let's say, 30 minutes, I would presume that if I watched that on a news program, that it was longer than that, and that the journalist cut it down, not out of some agenda to confuse anybody, but simply to fit the time or the scope of whatever the topic is. And so, without a greater showing of how that could possibly be unfair, I wouldn't go into the longer stuff anyway, or the longer interview as was indicated. So I'm not going to bring Mr. Van Dusen forward, nor do I think the court necessarily could. As to, and as I've indicated, I don't find that it was an improper production of those, given the timeline that the parties discussed yesterday, as I included in my finding, let's hope we know contempt of court that was requested. I don't think that there was irreparable harm. The party has requested in 106, which is proper to have a longer clip played. That is for the three that we talked about. The court does believe that's appropriate under the court rule, and that the ones proposed are appropriate. And given all of that, I certainly don't find that there is a manifest necessity for a mistrial in this case, so that request will be denied. Covered everything. Also, the court's not going to bring the jury out as a whole or individual jurors out as a whole to interview them. They took an oath at the beginning of this case that they would be fair and impartial in the standard oath, and based on admitted evidence, the court believes obviously that they will all do that. That is the only thing. So I'm going with that. I think I covered everything. Mr. Barnett, anything else for you?
The prejudicial nature of the UC sucker word, as well as the robotic comment regarding there were two exhibits that both included some support derivatives. And I think we're over the top, this is across the line, and we're not probative at all. We're prejudicial and done to inflame the jury.
And you made that clear that the court has overruled that portion of the objection. I do believe that it's probative for state of mind and intent, as well as put forth and requested by the people. And I don't think that the prejudicial nature of those words or that language being used substantially exceeds the probative value. And so I don't believe that there was anything there. Mr. Lindsay, anything else for you?
No, thank you.
Mr. Cyber, anything else for you?
No, thank you.
Mr. Walson, anything else for you?
No, sir.
Okay. What I'd like to do, though, is make sure that we get the proper clips. And so those are audio files that you have, Mr. Barnett.
They are.
Do you have the ability to edit those? What I don't want to do is start and stop at whatever kilo is going to be. I want to have as kilo, whatever Lima is going to be. I want as Lima.
I made it through the first round.
Okay.
Is the court, this whole thing is prejudicial, because we're replaying the case. The only way to fix this thing is to replay the
Okay.
case.
We've already had that discussion in the court's meetings relative to the length of the exhibits. Do you have the ability to clip out the end portion as we discussed? Or not?
Yes, I believe so. As soon as I think I know them well enough, I've spent enough time that I believe I can do that.
Okay.
They need to be played now.
I
When the
understand.
red line comes across, I can see where it's coming to the danger zone.
Mr. Barnett, we have had that discussion already. The court has made its ruling. Relative to the exhibits, let's do this. Let's take a couple additional minutes. I don't know if they're going to be put on a thumb drive or a CD or how they're going to be admitted. They will be played for the jury. What we'll do is, are you requesting in the same fashion that we did it today, where we play, for example, 262 and then play your kilo?
I think I have to ask the court to do that so that they will see the difference in what was adequately required.
I'm just asking. what
Yes,
this is.
yes, yes, yes.
I think that would be appropriate. Mr. Ralston, any issue with that?
No.
Okay, what I'd like to do is get whatever kilo lima in India set as those, and I don't know how they're going to be presented, if it's going to be on thumb drive. Certainly it can be admitted that way. Let's just get that figured out before we bring the jury back. Okay?
Judge, may I? Sure. Is Mr. Barnett suggesting that we do that before I cross Agent Impola, or?
I think he's asking that we would do that now, so if I understand his request correctly, what we will do is put Agent Impola back on the scene. Technically, the direct would be continued in order to deal with this issue.
Just as a limited purpose of addressing this?
Yeah. And then
We have no objection to that. I just want procedurally to make sure we're on track. Thank you.
Okay. Mr. Tucker?
Judge, we're at 10:30. You were expecting me in another minutes.
Okay, thanks. We can deal with that if it comes up. Mr. Barnett?
Is the court going to explain that if he's going to be bringing these in, would the court explain that the defense is objected to the clips that were played yesterday?
Yeah, I'll explain the process behind 106, what you requested, the determinations that were made in that process, and then after I explain that.
This is his presentation, not ours. I
I
expect,
understand.
okay,
I will
okay.
make that perfectly clear to the jury. What my intent is to bring them back in, explain the request that has been made.
Sure.
Explain to them that it is made at the time, so these three exhibits are being offered by Mr. Barnett. They will be admitted as Kilo Lima in India. What we're going to do is, because there's three of them, it relates back to specific clips. So we are going to play
Got it.
263 and then play Kilo. And then I'm not going to make it seem as though this is being offered by you. That's the process generally.
Understood. And just footnote on Ms. Keller and her counselor here.
Okay, we can deal with that before going back in front of the jury. Thank you. Okay, so let's figure it out. Let me know when they're prepared so that we can get when they can be admitted as actual exhibits, and then we'll deal with the scholar situation, and then we'll bring the jury back. Okay?
We have 2 minutes before we do a show.
Yeah, no problem. We'll do the exhibits first. When we're ready to go, then we'll take that.
Okay, thank you.
Or did you mean 2 minutes of turning?
No, I just, I didn't know if we were.
No, that's fine. We'll be in recess until those.
Thank you.
Ouch.
Would you mind moving your clothes just for a minute?
Sorry, my what?
Tape there, it's kind of blocking the sound. Would you mind removing that?
Oh, yeah.
Just
No
for
problem.
this, boom buster. Thank you very much.
Indeed, I'm not gonna have you sit at the witness stand for this. So you can-
Okay.
Just Mr. Walton. He's in the back. No problem. Everyone can be seated. In terms of what is it?
This,
We're gonna do that. Okay, let's go back on the record, before, we get to the, kilo being India 16 issue. Mr. Alton, coming to you relative to the issue that we talked about in January yesterday.
Yes, Ms. Keller with counsel is here. Court asked that she appear personally to put her assertion of her right on the record. We're prepared to do that.
Ms. Keller, would you come forward? Witness stand is here, ma'am. And before you take a seat, would you raise your right hand? Do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but?
Yes.
Okay, go ahead and have a seat for me. You can start off with just telling us your full name and then spelling your test, please.
Ronnie Amanda Keller.
A little louder and clearer.
Ronnie Amanda Keller, Keller.
And your name, sir?
Oh, sorry. Good morning, Your Honor. Brendan Casilla. I counsel for Ms. Keller.
And it's my understanding that Ms. Keller had the potential for being called as a witness in this case. Is that correct?
That is correct, Your Honor.
And the court appointed an attorney for her relative to any rights that she may have to waive or assert those privileges. Is that correct?
That is correct, Your Honor.
Have you consulted with her about that?
I have, Your Honor.
So, Ms. Keller, have you had sufficient time to talk to your attorney? Obviously, the potential existed for you being called as a witness in this case, but there are some potential rights that you have, and that's why the court appointed an attorney for you. Have you had a sufficient amount of time to speak with your attorney about those possible ramifications and implications for you?
Yes, I have.
And have you reached a decision as to whether or not you will testify in this case or invoke any particular?
Yes, I have.
And what is that decision?
I invoke my Fifth Amendment.
And would you invoke that right to any question asked by the prosecution?
Yes, I will.
Would you invoke that right to any question asked by any of the defense attorneys?
Yes, I will.
Anything else for you that you'd like to add here?
Nothing further. Thank you very much, Your Honor.
Any other questions that counsel feels needed to go through to ask Mr. Walton?
No, sir.
Any of the defense attorneys? Mr.
No, thank you. No, thank you, Judge.
Mr. Barnes?
Just curious if the same motion was filed in this court for court appointed counsel for this potential witness that was also filed for the witness box in this case that was a proposed witness.
Meaning was it requested that an attorney be appointed?
Yes, and that they're
Yes.
subject to the charges, known duty, granted, et cetera.
Yes, I believe it was. The court signed an order appointing the attorney.
Thank you very much.
Okay. Thank you very much, Amy. You are excused. You both of you are released.
Thank you very much, Your Honor.
Thank you both for agreeing.
Judge, I understand the procedure the court's going to use on the 106 issue. When we conclude with that, then I'd like to continue with Agent Impola on the three exhibits, which are proposed exhibits 121, 122, and 123, which are their Keller calls to the FBI.
Call.
Is it a single call and these are three clips related to that?
Exactly.
And the court would note that the people did properly notify accordingly of the parties that they had intended to do that, subject to the questioning that's about this morning. So, and certainly it has to be admissibility of 121, 122, 123. We can talk about that and what exhibits offered. And so the court has generally outlined a procedure will follow relative to Kilo, Lima, and India. And so, Mr. Burnett, the way that I understand this is you are prepared to play the audio for the timeframes that we have discussed previously. Is that correct?
I have, Your Honor, I've trimmed some time off because what it required me to watch my notes and to cut it off. There's nothing really prejudicial with the entry of a question in there. Voice, I will do my best to trim them. I will take them home tonight. I have an easier way of running my phone into a CD recorder, and I could make a thumb drive out of that. Of course, convenience. But I will stop at the same time. It'll be a fair representation of what's played in court.
Okay. And so, whether it's a CD or a thumb drive, that will be admitted as when we say Kilo, Lima, and India are admitted. That's what we see. That's correct.
That's correct.
Okay. Mr. Wilson, any objection to that?
Nothing.
Okay. Other attorneys, any objection to that? And by what I mean is that the physical exhibit would be actually on premises until tomorrow, which under the circumstances I understand why.
Leave it to the discretion of the court, Your Honor.
Okay, Mr. Sager?
No comment.
Okay. Then that's what we'll do. Anything else before we bring the jury back in?
No, sir.
No, thank you.
Okay, all rise for the jury.
May I pick the order of the exhibits?
You don't want to do 261, 262, 263, and then 264?
That Kilo, yeah.
Okay, we'll go on.
PLI.
Yeah, we'll go in numerical order of these.
No, we're going to do the exhibits first.
Okay, everyone can be seated. Ladies and gentlemen, good morning. And I can make that joke, but we did receive your note. There's a couple of things that I want to go over, and I'll explain what we're going to start this morning for a minute. But I did receive a note that said, how come we're ready by 9, but we never started at 9? And the point is well taken, and the answer is because that's the way that our process works. And I think that's not meant to be unfair to any of you. And I don't say that in jest. I just say the joke because I can, as best I can, understand how frustrating it must be at times. And it's one of the many reasons when people ask me, is being a lawyer or a judge or whatever like it is on TV? There are many reasons I tell them that it's not, but this is one of them because they get through whatever the saving the world thing is for that episode in an hour or 40 some minutes of commercials, and it's never quite that way. It is sometimes a long and slow process. It's very arduous, and there's nothing improper about that. That's not the fault of the attorneys, right? We've had to excuse you to talk about evidence before. There's nothing wrong with that, right? That's what they perceive there needs to be done. If there's an issue, they need to raise it with the court, and then there are things that we have to discuss by law outside of your presence. I steal a little bit of a joke from a judge that I used to appear in front of. He always said, when he went to new judge school some years ago, he made a matter of reference his age by saying the number of years, so I won't do that. He said, they tell you the first rule is never make the jury wait, and then the second thing they tell you is, but that's all you do. And It's not meant to be an insult to you or the time that you're giving to this process. It's not meant to be a poor reflection of the process or anything along those lines. Unfortunately, there are just rules and procedures for how everything has to take place to ensure that this is conducted in a fair fashion. That is my ultimate goal. And so even if I have to err on the side of caution at times, that's what I'm going to do. And so that's the long way of me telling you that the person to blame for any long things, such as starting at 11 instead of 9, that would be on me. Okay? And so it's perfectly appropriate for you all to feel that way. The reason I wanted to go through that is because I wanted to make sure that you're not holding it against anybody in the room other than me, so that we can be fair and impartial and remain that way throughout this process. Okay? The other little piece of that is just a reminder, no deliberations or discussion of the case can occur because discussion of the case would be a deliberation. So even if you are stuck back there for 2 hours, let's say on a given morning before we get started, you'll have to cover personal topics and nothing related to the case. Okay, just a gentle reminder there. Now, in terms of where we're going to begin this morning, you'll recall that we did conclude with the People's Direct Examination of Agent Impola. There was one topic that they, what I call reserved, meaning one thing that they were still allowed to bring up that we're going to get to after the first thing that we cover. You've heard me mention a couple of times when objections have been made as to clips or portions of them. You've heard me say 106 or Michigan Rule of Evidence 106. What that allows is if an exhibit is admitted from, let's say, the prosecution side, if it's a written or oral statement, let's say a video recording of the statement, an opposing party or another party can make a motion under that court rule to expand, so to speak, whether it's before or after, to provide what they believe is context fairness, or whatever word they want to use. And I think fairness is the one that's used in the court rule. To provide an expanded amount that would be admitted as another exhibit to provide that relative to the one that was admitted. And if you'll recall where we ended exhibits 260 through 264, those dealt with the interview with Mr. Mahler. The Knowles were not involved in that, just Mr. Mahler. And then 5 clips were.
And I think that anybody who says otherwise, here's something that irritates me. Any motherfucker that stands up and says, "Oh, I'm ready to shoot somebody," that's the easiest thing for you. You're waiting to fucking kill another American. There's something wrong with you, motherfucker. You know, that shit bothers me. The boogaloo should be the last resort because you've already tried doing stuff. These motherfuckers want to pull the trigger on another human being. People say this shit, they don't realize what real violence is, what it actually does to you, what it looks like. You know, it's real easy to do this shit. I think that should be the last resort.
On the Boogaloo Boy issue,
yes.
You brought up the Civil War, and from my experience in doing research on the Boogaloo, it runs the gamut from what I guess you would call accelerationists. Have you heard that term before?
No, but I understand.
Okay, so an accelerationist, from my limited research on it, is someone that is not only believe that a civil war is inevitable, which I think most of the mainstream Boogaloo Boy movement believe that a civil war is imminent. The accelerationists want to bring it about.
Yeah.
And so what's your take on the potential of a civil war breaking out in the United States?
Scares the shit out of me. It scares the shit out of me. I like being able to sit in my house and not have to worry about roving bands of cocksuckers, wanting to come rape, pillage, and kill people, because that will happen. You will find factions of people. You'll be surprised how fast things fall apart. And people are, man, I'm so sorry. I grab a whole lot of stuff. I grab a lot of stuff because there's so much that goes into it. Your questions are simple, but there's so much that goes into the question, for an answer.
So I guess, do you believe that a civil war is inevitable here in the United States because of what you've seen?
I'm going to say the civil war is inevitable, and no matter what country, no matter what government you have in place, because you're always going to have people who don't agree with the other side. And it eventually will culminate to something. I mean, just look at history. It's constant. There is not one country that's ever existed without civil war every once in a while. It is going to happen. It's cycling. So yes, I think it's I think it's inevitable. I don't know if it's gonna happen in my time. I'm hoping that people can invest themselves into learning and using the system the way it's supposed to be used to avoid it as long as possible. The last thing anybody should want to do is fight another human being.
What are your,
Your Honor, it was 3 minutes and 24 seconds.
And that was in, chronologers, exhibit K as in kilo. If we could play, People's Exhibit 26.
How would you believe someone should differentiate between like violent rhetoric compared to, just blowing off steam? How do you know whether or not someone's serious?
I'm very black and white. There's no crime until something happens. And I'm sorry that something has to happen, that somebody has to get hurt in order for my opinion to matter here. But if nothing has happened, there is no victim. Once there is a victim, then the individual who did the crime needs to be dealt with.
Okay. And then, Mr. Barnett, or Defendant Oliver's Exhibit L.
how do you differentiate, like we talked about the gun issue, how to differentiate between who's a bad guy, who's a good guy? How would you believe someone should differentiate between like violent rhetoric compared to, just blowing off steam? How do you know whether or not someone's serious?
I'm very black and white. There is no crime until something happens. And I'm sorry that something has to happen, that somebody has to get hurt in order for my opinion to matter here. But if nothing has happened, there is no victim. Once there is a victim, then the individual who did the crime needs to be dealt with. Innocent people who had nothing to do with it should not have any regulations placed on them because of something that somebody else did. That is not fair.
So
0 to 46 seconds, Your Honor, on that clip, which would be Lima L.
And if we could have People's Exhibit 264.
So when you were driving down, I think it's Timberlake Drive on Birch Lake, and Adam handed you his phone, and you took a slow-mo video that contained Governor Whitmer's vacation home in that slow-mo video. What did you think you were doing when you did that?
Oh, I know exactly what that was. I mean, it's obviously we take a slow or a video while we ride by. I'm not stupid.
And then we could have Defendant Oliver's Exhibit I.
So when you were driving down, I think it's Timberlake Drive on Birch Lake, and Adam handed you his phone, and you took a slow-mo video that contained Governor Whitmer's vacation home in that slow-mo video. What did you think you were doing when you did that?
Oh, I know exactly what that was. I mean, it's obviously we take a slow or a video while we drive by. I'm not stupid. How do you say no to somebody not knowing how far they want to go to keep you quiet? I don't know him. I do not know Dan at all. I shook Adam's hand once and I saw him on a fucking chat.
So do you think,
If I gotta take a video to get home to my kids, I'll do it again.
would you, it sounds like you're certain that you potentially were under duress when you did that.
It would be, except for they did not coerce me to do it. They did not actually tell me if you don't do it, you will be injured. I did not want to give them the opportunity to think that I would not be okay with them because they now know where the fuck I live. My mom is here who's not in the best of health. My kids are here. I had custody of my kids, dude.
So that was on April 29th of 2020.
Sorry, it's 1:12. 1 minute and 12 seconds.
Again, that was media, which relates back to the People's Exhibit 264. Those are the three exhibits, Mr. Barnett.
Those are, thank you very much.
Ladies and gentlemen, we conclude that matter. Mr. Ralston, let me go back to you. Would you like to recall a meeting and what for the purpose the limited purpose we discussed? Yes, we do. Okay, thank you. Before you sit down, do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, it's good. I have to turn this off.
Oh,
Thank you.
Good morning.
Good morning.
I want to direct your attention to proposed exhibit 121. Agent Impola, are you familiar with that?
I am.
Tell us a little bit about what that is.
This is an audio clip from a phone call that Amanda Keller made on August 21st, 2020 to the FBI.
You pull up the subject's investigation. And is Ms. Keller on the list?
Yes, on the bottom right here, this is Amanda Keller.
Okay, and tell us, if you will, if she had any relationship with Mr. Fox.
Yes. She was Mr. Fox's one-time fiance and a girlfriend throughout the investigation.
Okay, and we've seen her at different points and heard her voice at different points through the trial so far. Is that correct?
Yes, sir.
Okay, and tell us about the FBI. Does it have any type of, like, if I want to report a crime, can I call in?
Yes, so you could call the FBI and it goes to our intake center. So we've got, it's very similar to a local dispatch. Like if you were to call the police department and try to report a crime directly, we have a dispatch out in Washington, D.C. where you can call and you get an operator and they'll take your complaint.
Okay, and are those calls recorded?
They are.
Okay, and one proposed exhibit 121, can you tell us what it is?
Yes, this is a portion of the audio clip from Amanda Keller from August 21st when she calls the FBI to report a terrorist plot.
Okay, and what year?
2020.
Okay, and is there an associated transcript marked 121T with this exhibit?
Yes, I believe there is.
And is that transcript accurate as to the content of the audio?
Yes.
Okay. And I'm going to move for admission of proposed exhibit 121 and 121T, please.
Mr. Miller? Mr. Seibert?
Just please stand up, there's no objections, thank you.
Mr. Burnett?
No objection, Your Honor.
The court has had a chance to review 121T as to the content, which would be admitted with 121 pursuant to 804. A1 and then B3, given the content as well as earlier rulings by the court, 121 and 121T will be.
Before we play that, just kind of going back a little bit, you've told us about her relationship with Mr. Fox. Did Ms. Keller appear at the Dublin New Founding Fathers meeting?
Yes, she did.
Okay. Do you know whether or not she was in Cambria, Wisconsin for the Cambria FTX?
Yes, she was.
You've told us about a meeting at Mr. Fix's residence in Belleville on August 1. Was she there?
Yes.
Okay. In terms of the meeting at the Vac Shack with the Wolverine Watchman in June, was she at that meeting?
Yes, she was.
Okay. All right. Adam, if you could play that, please.
The And what federal crime or federal violation are you calling to report today?
Domestic terrorists.
And who would that be?
There's a lot of them.
Okay, when did you see this activity?
There's multiple states that are involved. There's Michigan, Wisconsin, Illinois, Ohio, and Delaware.
And when did you see this?
I have been to a few of their meetings.
And when was that?
I can't tell you the dates, ma'am.
Can you tell me approximately? Was it a week ago, a month ago, a year ago?
We know it's been this year. We traveled pretty much, I want to say May or June up until, last month, I think was our last meeting. I can't remember when we were in Ohio. I don't remember.
And who is it that's having this meeting? Is there a name of the entity?
There's a bunch of them. Like I said, it's a multi-state thing.
Okay.
I know who the leaders are.
So there's multiple groups or entities?
Yes. But they're all conjoining together to get this done.
And are you a member of all of these groups?
I was a member of one of them, yes.
And what group was that?
I was, my ex-boyfriend started his own militia, Michigan. What is it? Michigan. Oh, I can't remember what it's called. It just started, Michigan Group of Members, or I can't remember. It just started.
Okay.
Facebook purged the page, so I can't even find what the name was.
Okay. Okay, so when you say that you were attending meetings, whose meetings were you attending?
So the leader of the meetings was Barry Gordon.
Agent Impola, are you familiar with proposed exhibit 122?
I am.
Can you tell us what that is?
It's another audio clip from the same phone call from Amanda Keller to the FBI complaint intake.
And generally, what does this portion of the call address?
It just describes Amanda Keller's knowledge that the plot was to kidnap Whitmer and kill her.
Move for, and is there an associated transcript mark 122T that accompanies this audio?
Yes, there is.
The transcript accurate as to the audio?
Yes.
Going to move for admission, please. Propose exhibit 122 and 122T, please, Judge.
Mr. Nunzi? Mr. Cyber?
Thank you, Judge. We stand on our written objections.
Mr. Barnett?
Curious of the date of this phone call, if we repeat the date of the last one, or is this the same phone call? And what's the date of that?
It's my understanding is that this exhibit related to the same phone call that agent, what date was this call made?
It's August 21st, 2020.
Mr. Barnett, let me go back to you.
Is there a reason the phone call just doesn't follow one stream, cut in parts?
Do you have an objection to the admission of 122 or 122T?
Only because there's a gap again. There's a gap here.
Well, then the procedure for that has been reviewed. Do you have any objection beyond that?
No.
Okay. Based again on previous rulings by the court, as well as 804A1 and then B3, I did have a chance to review proposed exhibit 122T, which would be the content of 122, and I'll make the same finding that under previous rulings and the 804 sections previously set by the court, 122 and 122T are.
Adam, please.
Plans in place for Michigan that they're going to kidnap Governor Whitmer and kill her. blow up buildings, blow up the electric grid, and go after the news stations. Again, that's just Michigan's plan. There's also Wisconsin, Illinois, Ohio,
Do you know when they plan to do this?
within the next couple months.
Agent Impola, are you familiar with proposed exhibit 123?
I am.
Can you tell us what that is?
This is another clip from the same phone call from Amanda Keller to the FBI intake. It's from August 21st, 2020.
Is there an associated transcript to this with this marked 123T?
Yes,
And is that transcript accurate as to the audio?
yes.
Move for admission, please, of, well, tell us if you will, generally, what is the content of 123?
It's Amanda Keller's concern for the group having explosives and incorporating that into the plan.
Move for admission on 123 and 123T, please, Judge.
Mr. Sacker.
Judge, we stand on our written objections, thank you.
Mr. Barnett.
Same objection, limited objection that they have to do isolated, but
And those are noted for the record. As the previous rulings with 121 and 121T, the same with 122 and 122T, the court did have a chance to review 123T, proposed exhibit 123T in terms of the information that would comprise 123, and the court would make the same rulings with 121 and 122, 804A1 and B3 based on the content as well as previous rulings by the court. So both 123 and 123T will be.
He's holding the meeting September 11th and 12th. They're inviting guys out there that do explosives. They're inviting them into the plan. They're going to be exploding stuff out there. There's going to be a lot of guys and a lot of guns.
Thank you very much, Judge. I'll yield the witness.
Or Ms. Lindsay.
Yeah, courthouse.
Okay. Ms. Lindsay, go ahead.
Can we have the lights, Your Honor?
Good afternoon, Agent Impola.
Good afternoon, Counselor.
If there's anything I ask you that you don't understand, let me know, okay? Okay.
Sounds good, thank you.
All right, so you talked about the Wolverine Watchman, and that's how you started your investigation, correct?
Yes, ma'am.
And while you weren't watching that organization, that group, they started in November of 2019, right?
Well, I started my investigation in March, and then I learned historically that they had started in November, but I wasn't aware in November of their existence. I didn't learn that until actually after search warrants had been executed on Facebook.
Right, I acknowledge that your investigation started later, but you learned that their organization started around November of 2019, correct?
Yes, ma'am.
And you learned that the Wolverine Watchmen, they kind of had an oath, correct?
They had a vetting procedure, if that's what you mean.
Well, didn't they also have oaths that they took?
No.
No? Okay. You talked in your testimony about Adam Fox and Sean Fix taking an oath. Was that with the Wolverine Watchmen or was that with a different group?
So they took an oath in the presence of the Wolverine Watchmen, but the oath was not for the Wolverine Watchmen. It was for Adam Fox's group.
Okay. So just so that the jury fully understands, Fox and Sean Fix, they took that oath in front of the Wolverine Watchmen.
Yes, that's correct.
And just the Wolverine Watchmen, Adam Fox and Sean Fix were present during that time, correct?
Yes.
All right, I'd like to move your attention to April 30th of 2020, the American Patriot Rally. You testified that there was no interaction between the Knoll brothers and the Wolverine Watchmen, correct?
Not to my knowledge, that's correct.
And there was no interaction between the Knoll brothers and Adam Fox?
Not to my knowledge, that's correct.
And I believe you testified that the Knoll brothers were lawfully exercising their First and Second Amendment rights during that rally.
Yes.
And I think you even said they worked some form of security during that rally.
I could see some sort of security badge on the photographs that they were wearing that seemed to be referencing the American Patriot Council. So it seemed to be associated with the rally.
So some sort of security.
That's correct.
Now I want to draw your attention to the American Patriot Rally in Grand Rapids. That was May 28th of 2020, correct?
If my memory serves me, it was May 18th of 2020.
Okay, so May 18. And you testified that I think maybe Eric Mulder was there and Adam Fox.
I saw photographs in which Adam Fox, Eric Mulder, and the Knoll brothers were present at that rally in Rosa Parks. So,
Okay, and there was no interaction, to your knowledge, between the Knoll brothers and Adam Fox at that time?
I don't know of any interaction, but my knowledge is just based on looking at photographs. So I wouldn't have the ability to know from those photographs if there was interaction or if there wasn't. I just saw the photographs of them there at the rally.
Okay, and then I guess in the same vein, you don't know if there was any interaction between the Knoll brothers and Eric Mulder.
That's correct. Yes,
Okay.
that's fair.
Now, you said you looked at photographs online of this rally, correct?
That's correct.
And some of those photographs were admitted as evidence in this case.
That's correct.
In some of those photographs, isn't Bill Knoll in the photo with Darleaf, the sheriff of Berry County?
I saw a number of photographs of Bill Knoll with Darleaf. So each particular photograph that I would see, I would try to source that. And so Bill Knoll and Mike Knoll are frequently in photographs with Darleaf. And I don't know if it occurred at that rally or not, but I think it's fair to say that there are a number of photographs of them with Darleaf.
And just so the jury is clear, he's the sheriff of Berry County, correct?
Yes, ma'am.
Okay. And I think, again, you testified that the Knoll brothers were lawfully exercising their First and Second Amendment rights at that rally as well.
Well, I don't have any details about what they have at the rally. All I have is the pictures, but I certainly agree that they weren't arrested at that rally and they were open carrying firearms.
So I want to turn your attention towards the end of May of 2020. Are you familiar with George Floyd?
I've seen news reports.
Okay, and George Floyd was murdered by a police officer, isn't that correct?
That's my understanding. I believe there was multiple police officers who were involved.
Yep. And during that time, is it fair to say that Americans had a reaction to what happened to George Floyd?
I think that's a fair statement.
In fact, there were riots in Grand Rapids, right?
Yes, ma'am.
And there were riots in Wisconsin, Portland, Oregon, right?
It sounds fair.
Yeah, and honestly, because there were riots, a lot of police officers, they were wearing riot gear, if you know from your review of news articles, right?
Yes, I think it's fair that some departments deployed riot gear during those times.
I mean, tear gas was kind of used too, right? To break up some of these riots, if you're aware of it.
That's a general fair statement, I believe.
Okay. And then I think you testified that there was a riot response in Grand Rapids on the 31st of May, 2020, right?
We entered a picture of a response. Yes. Yes, ma'am.
Is there any way that could have been in Lansing and not Grand Rapids?
It's possible. I got the photograph from Adam Fox's phone and he talked about deploying to Grand Rapids, but I physically wasn't there and I didn't deploy with him or have any surveillance. So my basis of knowledge is just based on what Adam Fox said. So it's possible that it could have been a different location.
So essentially, just to summarize, you can't verify Fox's statements as it relates to May 31, 2020.
All I can tell you is what he said and then the photograph that he had on his phone around that date.
Right, but you can't independently verify where that photograph was taken, correct?
I'm correct. I'm not sure where that photograph was taken.
And I think you testified that there was no interaction that you know of between the Knoll brothers and Adam Fox during that riot response, correct?
That's correct. I have no information about their communications.
And again, I think you testified that they were lawfully exercising their First and Second Amendment rights on May 31 of 2020.
Well, I know they weren't arrested. I believe they were open carrying. I don't know what extent they did patrol the city, if it was Lansing or Grand Rapids. So it seems certainly likely that they were protecting or they were using their First and Second Amendment rights, but I don't have a lot of details about what actually happened.
I want to draw your attention to June 4th of 2020. You had testified about some secured chats between Adam Fox and other individuals. Just to clarify, the Knoll brothers weren't a part of those chats on June 4th of 2020, correct?
Let me check the
Yeah, you
exhibits here,
can
if you don't
can
mind.
refer. Yep. And it just for a point of reference, I think it is number 5 on Exhibit 2.
Oh, the significant events timeline. I'm looking here at starting at Exhibit 24.
Agent, wouldn't it be helpful if I approached with the significant event timeline for you?
Yes, that would be great.
Your Honor,
Thank you.
may I approach?
And that's exhibit 2.
Yes. So read through that, and if it helps refresh your memory, let me know.
And I think, are you referring to Exhibit 5 here on 6-4?
I'm sorry, if I said 4, I meant 5. Yep.
Okay. Yes, I'm familiar with that.
Okay, did that refresh your memory?
Yes, ma'am.
It was that box 5 on exhibit 2.
Yes, Your Honor.
Go ahead.
So the Knoll brothers were not a part of those private chats, correct?
Correct. That was a one-on-one communication between Eric Molitor and Adam Fox.
And so the Knoll brothers at that time didn't agree to be a participant in a civilian army that Fox was running.
Well, as of May 22nd, the Knoll brothers, let me step back.
So my question specifically relates to June 4th, those chats.
Correct. So as of that time, June 4th, I'm aware that before June 4th, on May 22nd, the Knoll brothers had been in communication with Michael McDonald and had been invited to the Dublin meeting. So.
Right, but there's no text message.
I think the witness is being cut off in his answer. I just asked the court to allow him to finish his answer before the next question is asked.
Well, and this is not just a question related directly to the 24th messages, though I do understand the series of message may affect that answer. But I think the question was that on the messages specifically as to June 4th, the Knolls were not on that particular chat. Is that the question?
Yes, Your Honor.
Agent, do you know the answer to that question?
So as of June 4th, the Knolls were not part of the Eric Molitor, Adam Fox chat.
Okay. Go ahead.
So I want to move your attention to June 6th of 2020. I know that during this trial, you've referred to that Dublin, Ohio meeting as the new Founding Fathers meeting, correct?
Yes, ma'am.
but you previously testified at the prelim, and you called that meeting just the National Meeting of Leaders. Isn't that correct?
That's correct.
And specifically, with that Dublin, Ohio meeting, people were coming and going during that meeting.
My understanding is that some people left the room once the meeting had started. I don't know if people came, but I'm sure that during the course of arranging people and bringing them into the hotel that people were coming and going prior to the meeting and then definitely after the meeting.
Let me ask you this. You live monitored that meeting, correct?
No, ma'am.
You did not live monitor it?
No.
So you just listened to the recordings after the fact?
Yes.
And during the course of your investigation, you talked with other agents as it related to their debriefing with Steve Robeson and Jennifer Plunkett, correct?
Generally speaking, yes.
And they actually notified you that people had left during the meeting, right?
I did learn that that some people had gotten scared and left.
And but that came from your conversations with other agents, correct?
Yes.
And I believe you testified that that meeting was like roughly 2 hours, could have been longer.
That's an estimate I have based on the recording. And it's just a rough recollection. I'm trying to remember.
I know it was a long time ago. Yep. But the meeting was at least 2 hours, right?
It seems fair.
Okay, I want to move your attention to June 17th of 2020. You stated that that's when there was a signal chat with militia leaders, correct?
Yes, ma'am.
And I believe on, I think the third day of your testimony, you testified that Brian Hennin started that new Founding Fathers chat, correct?
I don't recall what day. I'll take your word for it, but yes, I do recall. That's my memory, is that Brian Hennin had initiated the chat group.
So on Exhibit 2, Box 7, you have stated that Bill Knoll started that encrypted chat, the new Founding Fathers. So would that be a mistake?
I believe you're looking at an old exhibit. I did initially think he started that,
Okay.
and then I had corrected the exhibit, and our actual exhibit published to the jury says that he's a participant. So the exhibit number 2 as it stands is correct.
Okay, thank you for correcting that. So Bill Knoll did not start the new Founding Fathers chat.
That's correct.
All right, thank you. So moving to, I guess, the next significant box, you have box 8. There's, continued encrypted chats between Adam Fox and other members such as Eric Molitor. The Knowles weren't on those private chats, correct?
Oh.
So box 8 of
Yes.
Exhibit 2.
So correct. So right here, box 8, the 623 chats on wire, those are just the direct one-on-one from Eric Molitor to Adam Fox.
Okay, so moving your attention to the next box, you testified that there was text messages between Fox and the Knoll brothers regarding an in-person meetup, correct?
These were wire messages, but yes.
Thank you for correcting me. And there was no independent work done to corroborate whether or not that meeting happened, correct?
Correct.
And I think it's because you didn't have someone on Fox at that time, correct?
This would have been. So we would have initiated an investigation shortly after Dublin. So after the new founding fathers meeting on number 6, we would have learned of Fox. And so I do believe we would have had a case agent assigned by this time. But we didn't have a method of, we didn't know where the meeting would take place. And we didn't have any surveillance coverage or any encrypted comms or any sort of source that was available. We didn't have any ability to obtain a recording. So there was no tracking or no FBI or Michigan State Police way to learn about that meeting.
Well, I think you testified, right, that you, through search warrants, had received both the Knoll brothers' cell phones, correct?
Just prior to the takedown, we
Yep.
had executed, oh, I'm sorry. I was thinking of ping warrants. So you're talking about the physical cell phone
Yep.
following the takedown?
Yep.
Yes, ma'am. We did have search warrants and we did have the Knoll brothers' cell phones.
And you just talked about ping warrants. When were those done?
Those were done just prior to the takedown to try and get their location for the arrests.
Okay. Well, you did testify that you had gone through both Bill and Mike's cell phones, right?
Correct. Following the October 7th arrest, I was able to review them.
And outside of the text messages that have been admitted, there was no cell phone logs or other text messages that pointed to an actual meeting on June 6th between the Knoll brothers and Fox, correct?
Well, June 6th was the date of the new founding fathers meeting. I
I'm
believe
sorry.
you're referring to June 30th.
June 30, yep.
Yes, ma'am. I have no other evidence about the June 30th meeting, and I didn't see that evidence on their cell phones.
Now, right before June 30th, there was an FTX in Munich, correct?
Oh, yes. The 628 FTX in Munich was between items 8 and 9 here.
And that was with Adam Fox and the Wolverine Watchman, correct?
Yes, ma'am.
And I think you testified that there was, Pete Musico brought like an what did you call anarchist cookbook to that FTX?
I did reference Pete Musico's anarchist cookbook. That was screen captures from the original meeting back in March that we had with CHS Dan. And I've testified in other court proceedings about his anarchist cookbook, but I don't believe I've brought that up yet here today in front of the jury.
Okay. And remind me, the Knoll brothers were not at that Munich FTX with the Wolverine Watchman.
That's correct.
Okay, I want to draw your attention to 7/11 of 2020. That was Cambria, correct?
Yes, ma'am.
And I believe you talked about that photograph that was admitted, the group photo. There's about 27 people in that photograph, correct?
I didn't count them, but it seems to be a fair count. I don't have any problem with that.
And I believe at the prelim, you estimated that there was approximately 30 to 50 people at that FTX.
Yes, ma'am.
And not all of those people were charged, correct?
That's accurate.
And I believe families were present at that Cambria FTX, correct?
From reviewing the picture, I believe there was at least one family. I don't know all of the familial relations from the Wisconsin Patriot 3%ers, but I recall seeing a father, a son, at least a father and a son in the photograph.
Okay. There could be more families present, though.
Certainly could be.
So there might have been a somewhat social aspect to this FTX, as well as just the field training exercises.
I think there's Certainly a social aspect to a lot of militia activity.
And I think you testified on direct exam that there was a shoot house that was assembled at this FTX, correct?
I had called it a kill house for this one, but yes, those terms have been used interchangeably at various times.
And I believe you testified that the Wolverine Watchman group was one of the group that ran through that shoot house.
Yes, ma'am.
And then there was a second group that ran through it, and that was Amanda Keller, Sean Fix, Adam Fox, and Ty Garvin.
I'll kind of step through that. There's multiple videos, but I couldn't tell you like an order of the group for a first and a second group. There was multiple groups that were rolling through all the stations. And then
Agent, would it be fair to say that that was at least one of the groups that ran through was Keller, Sean Fix, Adam Fox, and Ty Garvin?
I'm recalling the videos, and I don't think Ty Garvin was part of that group, but
Okay.
Certainly Amanda Keller, Adam Fox, and Sean Fix, I recall seeing a video of them going through the shoot house.
And I believe you testified that you weren't sure when the Knoll brothers left Cambria, correct?
That's correct.
So they could have left right after the photograph was taken on the first day?
It's possible. I also don't know when the photograph was taken.
I think you testified that it was at least daylight hours, correct?
Yes.
So moving to July 18th of 2020, I believe that was the Peebles, Ohio meeting. I think it's box 12 on Exhibit 2.
Yes, ma'am.
And I think you testified that Barry Croft, Adam Fox, Sean Fix, Undercover Dan, Amanda Keller, Steve Robeson, Ty Garvin, and Caleb Franks were present at that meeting.
Yes, CHS Dan was present. He's not an undercover, but yes.
Oh, I'm sorry. Thank
No,
you.
you're fine.
The Knoll brothers were not at that meeting, correct?
I don't have any information that they were.
And I believe you referred to that meeting as attended by the leaders of the Boogaloo, correct?
Yes.
And during that meeting, you learned during the course of your investigation that the final plans for the mission were determined and all the states had input during that meeting.
That was supposed to be the plan from Barry Croft prior to going into the meeting. So he had told his followers, he told Adam Fox that was going to happen. Ultimately, that did not happen at Peebles. So they did not make a final plan. There was a number of plans presented, but the group could not come to a consensus as to which attack plan would be selected and which state would go first.
So it'd be fair to say that at least the purpose of that meeting was to determine the final plan.
That was the intended purpose, yes.
Okay, so I want to move your attention to July 27th of 2020. I don't believe that there is a box for that, but I think you testified on direct that that is when the FBI moved confidential human source Dan from the Wolverine Watchman towards Fox because of the statements that Fox had been making, correct?
That's certainly right around the time frame where we tasked Dan, and I told him that he needs to follow the violence and start. If Fox offers him the opportunity, then he needs to go towards Fox.
And you've talked a lot about the FAFO chat, and I think you've referred to it as the operators chat a couple of times during this trial.
Yes, ma'am.
And it's fair to say that the Knoll brothers were not on the FAFO or operators chat, correct?
That's correct.
All right, I want to draw your attention to August 1st of 2020. That would be item 13 on Exhibit 2. That would be the roundtable meeting at Sean Fix's residence in Belleville, correct?
Yes.
And you testified that Adam Fox, Sean Fix, Amanda Keller, and undercover Mark were at that meeting, correct?
That's correct.
And I believe you said you live monitored that meeting as well.
Yes, ma'am.
And through that live monitoring, you learned that this group came up with a series of locations for possible attack plans, correct?
Yes.
One of them being Mackinac Island and another of them being a cabin up north.
Correct. And another was the governor's residence in Lansing.
And during that Belleville meeting, they talked about the feasibility of each plan, correct?
Yes.
Including operational security, correct?
Yes.
And how to avoid being caught, correct?
Yes.
In fact, Amanda Keller kind of suggested that the group needed some information on the Mackinac Island residents, correct?
I don't remember who said it, but Amanda was certainly part of the discussions with Adam Fox about Mackinac Island, and I do recall that they said they wanted more intel on Mackinac Island.
And this was the meeting that Sean Fix offered a Black Hawk helicopter to the group, correct?
Yes, ma'am.
And he said that that could be used to further this plan.
Yes,
And the Knoll brothers were not at this meeting, correct?
that's correct.
Okay, I want to draw your attention to August 9 of 2020. That's not on your chart up there, but there was a FTX with the Wolverine Watchman, correct?
Yes, ma'am.
And the Knolls were not present.
That's correct.
And I think you said that the Wolverine Watchmen were there, including Morrison, Sean Fix, confidential human source Dan, Ty Garbin, and Caleb Franks, correct?
Yes, among others. It was a larger meeting, but yes, those members were there.
And during that meeting, Sean Fix had indicated that he wanted to start the Boogaloo with this plan to kidnap the governor, correct?
I believe that's a fair assessment. Sean Fix had discussed how this will kick off the Boogaloo and there'll be more to come. So this is kind of the opening shots in the war, so to speak.
And I think they talked about how it would be preferable if there were 8-man teams in order to execute this plan that they wanted to do, correct?
Yes, ma'am.
And this, again, was another time that Sean Fix had offered, I think, a Connex box of weapons.
Yes.
What is a Connex box?
A Connex box it's one of those corrugated metal shipping containers that you can put them on like railways or boats, and you can stack them. They're rectangular in shape, and then they fit on semi-trucks. So I think they're about 40 feet long and probably about 8 feet wide.
And how many weapons or types of weapons did he offer to the group's disposal?
He made some broad statements about having 50 caliber rifles and machine guns, but he never specified like a total that he had. He just said he had a secure Connex box at another location where he had weapons at his disposal.
Connex boxes are pretty large, aren't they?
Yes, ma'am.
So if he said it was full of weapons to use, that would kind of be a lot of weapons, wouldn't it?
It would be a lot of weapons.
Now we're getting.
Absolutely can. And actually, Well, no, we'll come back to that. We'll take a 10-minute break. Everyone can be seated. The record can reflect the jury is held at the courtroom. We'll take a short break. Apologize for the interruptions, anything from anybody before we take a break, Mr. Ralston?
No, sir.
Mr. Orr, Ms. Lindsay?
Your Honor, I have just a few questions following up. So I think maybe after my cross would be a great time for lunch, but I just want to let the court know that.
Yeah, sorry, I looked at the clock, so my natural reaction was to say we were trying to go to lunch, and then I didn't want to interrupt the cross, so that was the clause by the court. Mr. Stiver, anything for you before we take a break?
No, sir.
Mr. Barnett, anything for you?
Just a couple of things. I probably would be not able to do my work from the podium. I wondered if the court would allow me to move my table over, with or without my client. I just have a lot of documents with this book here, the evidence book, and several other things.
How about we keep you at your table?
That would be fine too.
Okay.
No objection. No objection.
Yes, keep your grant.
Well, I just, moving the table, getting all the cords and everything would be a lot, and so if you're okay staying there, you have it laid out, so that's why.
I kind of have it laid out, as long as the witness is okay, he's gonna have to look, I know. Sure.
No objection.
Okay. You're ready to say something like that.
We have my exhibits that I would be providing. I'd like to bring them in on cross if possible and get them over with, so to speak, not to say it like that, but have Mr. Impola is going to help me get some exhibits in. I think they might fit with my cross, and that way I'll call them back as a direct witness. And I'm just going to ask them to identify things. We have agreement with the prosecution.
Sure. The court will take a look at what our exhibits when they are offered, and we'll look at that.
Thumb drive for.
Okay. Anything else before we take a break?
Just briefly, thank you for popping up Exhibit 2 for me. I really appreciate that.
And if you all wouldn't mind continuing to do that, that would be.
Absolutely.
So that way.
No, we were told.
Okay. Anything else before we take a break, Mr. Barnett? Is that it? Okay, let's take a break until order passes, so that way you all get to.
You know,
I'm Jada Johnson.
The following segment is sponsored.
I'm Jada Johnson from Big Boys TV, and the Fish and Game Report is sponsored by Johnson's Propane. I'm Jada Johnson from Big Boys TV, and the Fish and Game Report is sponsored by Johnson's Propane.
The following segment is sponsored by TBA Credit Union.